Allora, buongiorno a tutti.
Good morning, please. It's Luigi De Chini. I work for UIL, and I work with that confederation regarding certain specific projects, including this project. The case that I would like to speak to is that of the draft labor regulation for the riders formulated by the logistics and transport sector. It's a contract which was signed in December 2017. There's going to be an additional protocol, or there was an additional protocol added in July 2018. Now, Martin addressed this subject, so did Ivana. They spoke of an experience when it comes to a representation in the service sector. Why did we choose that? Because the renewal of the 2017 contract, which took place after 2 years of work, attempted to include cases in which there wasn't any specific declaration. For example, when it comes to the travel of people who had to travel for their work, the riders weren't sufficiently described. But that's a category that exists above and beyond the simple food deliverers. For example, all of those who deliver small packages or documents or letters. And they were speaking of, the DHL or things like that. Something that goes beyond food delivery. But for those of you, those of them who, those who issued the contract want to take account of the fact that there's a lot of fragmentation in the different contractual conditions. For example, in Amazon, people are used to belong to cooperatives, but it's not like the sort of cooperatives that Matisse spoke about. The contract of 2017 and the protocol of 2018 were not approved by the big food delivery companies, because of the fact that they were relatively recent. However, it was signed by organizations that represent transport logistics sector. Now there was a careful analysis of the working conditions of the riders through a series of interviews with these riders in other places of work, or the riders who came to the union headquarters to discuss this with us. Now the contract attempts to regulate working hours, pay, classification of work, and the relation to the type of work and a wage scale. And there's a minimum hourly rate established with a rise after 6 months and after a further 6 months only for those that use motorcycles. The working hours provide a weekly limit of 39 hours over a maximum of 6 days in a given week. There's a minimum duration of 2 hours per day and a maximum of 8, which may be extended to 10 if the additional 2 hours are linked to work in a warehouse or something, not actual travel for delivery. And all of that can take place within a lapse of 13 hours in order to take account of the minimum flexibility needed by these companies, and also because of the need for the workers to rest. The minimum is also recognized in the part-time contracts. For the 2-hour minimum is also present in their contracts. The communication of a possible increase in working time or modification to the organization of working time must be made at least 11 hours in advance. Must be delivered by the company at least 11 hours in advance. An important innovation in the contract is the independence with respect to the reputation rating. I mean, there's a whole series of gray areas and hidden criteria that have a sort of that is drawn a link between the ranking and the actual working conditions. At times, I mean, the workers have even been unduly harassed. This is something that was uncovered in the case study. There was the case of a worker who needed 30 days of sick leave, who had to who had communicated to the company that he needed 30 days. But he was one of the highest ranked employees, but all of a sudden his ranking was brought down to the lowest levels because of that, and he was treated differently. The contract also concerns the rights to safety, the need to provide protective measures, to provide insurance for liability, and they're subject to other rules, other company rules. The effect, the beneficial effects of that contract, the fact that even though the biggest food delivery companies aren't involved, nonetheless it represents a reference point that many use. For example, the lawyers who support the food riders, they speak of this as being a reference point to help to justify pay modifications. There's a specific element, that's the recent element. This is a contract between a Florence-based food delivery company and the 3 main associations in the transport sector, including my union, including the UIL, that is, that sets forth a series of conditions that that are taken directly from the national contract for transport and logistics. So the 10 hours per week, minimum 10 hours per week, the 39 hours maximum per week. It introduces the 16 weekly hours, 16 hours of availability per day, which are already present in other contracts regarding deliverers, and also an average time for delivery. So that represents a precedent, even though its scope is limited for the time being. For any discussions in the government regarding regulations covering riders, as well as for other contexts. Thank you.
Merci. Thank you very much. I suggest we move on now to a discussion, and it's Michele who's going to introduce it.
Martin and Pierluigi, very good. And I believe that we are now entering in the key items of this phenomenon, because we are dealing with two items. The first, and this is also a query for both of you. The first is the function of the employers, because we are facing with employers that decide to step out or to be not enrolled in the employers' organization because they do not want to apply the collective bargaining. So we should understand in the next future if in Italy, in Germany, in France, in Spain, Poland, given our legal labor system, this decision to be not enrolled or to step out is a key business decision that is aimed at avoiding the application of the collective bargaining protection. And if it is true, we should understand if we have an alternative as a strategy, as and also as a legal tool against, because it's a sort of dissimulation or an effect of. The second item, and it is also a query, is linked to the choice of the collective bargaining, the choice of the sector. If I correctly understood, in Spain we have the restaurant sector, hotel, restaurant, tourism sector, collective bargaining that had a preliminary approach to the gig workers. So they try to find something as a solution. In Italy, we have the transportation, the logistics sector. Now, if you correctly understood this point, I repeat, is a key matter because there is also a sort of competition amongst sectors, amongst collective bargaining, and is a good competition. But however is a competition because we have to find a way to fix in the personal scope, the classification area of the collective bargaining, the professional, the workers, the gig workers, the tasks, and as a consequence, the link to the sector. So this is a second point that I believe is very important. And if I correctly remember, Feliciano maybe was with me, we had in Italy a long interview with the CFO of Deliveroo, and we understood that in the next future, Deliveroo would like to base his own business strategy on the idea to have no longer restaurant, but just kitchen, without waiters, and with gig workers moving around a building or a quartier to circulate foods. Now, if you take this example, and if you move this example in other sector, you get immediately the future of this kind of business. So I would like to have this. I mean, if you have some feedback on this point. So the first is the employers' enrollment, the employers stepping out, and the second is which sector, which collective bargaining should be mainly involved in this kind of process.
First, Barbara Sołdykowska. I work as a legal advisor for Polish trade union Solidarność, and if I may, some comments from Polish perspective, because we have to have in mind that if we want to speak about the change of the position of employers in some sectors, there are countries like in Poland where never been a proper collective agreement on the sectoral level in restaurant, catering or tourism industry. This is connect with the fact this is one of the reasons, that there are simply no employer organization, for instance, in hotel sectors in Poland or in restaurants. There are organizations which, from the legal status, they are a kind of association, and they play a kind of lobbying role. Of course, they are making a lot of service for their members, for this company who are the member of this organization. By definition, they do not want to be engaged in any kind of negotiation or social dialogue with the trade union. Just last sentence, what is the biggest challenge right now from the Polish perspective, because it's even more complicated right now, is the question of third country nationals, especially in the restaurants or in the hotel sector. Because it's even more complicated to organize people who are coming from different backgrounds. We have more and more workers from Ukraine, and in these sectors we have more and more workers who are coming from completely different backgrounds, from Far East, from India or from Bangladesh. And honestly speaking, for Polish trade union, it is quite a big challenge. I mean, also in kind of psychological reason, not only simple legal issue, to have a new strategy to organize people with different background.
Thank you. Nacho.
Thank you very much. My name is Ignacio Doreste, and I am an advisor at the European Trade Union Confederation. With regard to the first question about the role of platforms as employers and therefore their obligation to observe the respective collective agreements, I wanted to share with you something that the ETUC has been calling for very many years towards the European Commission. We are basically backing two reports of the European Parliament on the platform economy. These reports were defended by two MEPs, one Nicola Dante from Italy, again a member of the Social and Democrats, but the other one it was defended by a Finnish MEP from the Popular Party. So we see that we are creating alliances from different political parties of the previous parliament, which is reaching to an end, as you know. So these reports were calling the European Commission to explore to what extent already existing good protective mechanisms, as the directive on temporary workers agencies, could be applied to the platform economy, because what they see is basically there is a triangular relationship. There is a company, there is a worker, and there is a client, and we have a very good protective system which is very well implemented at the national level. So why not this could also be applied to the platform economy? So these two reports are from, I think, 2016. The European Commission, to our regret, hasn't taken the baton of this request. Well, as you know, the European Commission for many years has been calling for not to regulate at all in order not to kill this growing economy. We even question to what extent this is an economy itself, because we are talking about already existing sectors which are being deregulated. So we for many years we regretted this approach of not regulating, and not only not regulating but also asking national governments not to regulate, not to strangle this growing economy, and so on and so forth. Of course, now there is this window of opportunity, and we acknowledge that there is a change of so far of narrative with some developments after the proclamation of the European Pillar of Social Rights. But when it comes to the platform economy, still all the work is to be done. So this is one of the things that I wanted to share with you. Then something which was discussed before the coffee break. You were talking about the issue of the reclassification of workers, of self-employed. Virtually all workers in the platform economy are self-employed, and you were talking about the need to reclassify these workers as regular employees of the platform. The position of the ETUC at this regard is the following: we totally back all the actions taken by our affiliated organizations in reclassification strategies. So we can only applaud what you are doing towards the employers and your respective courts. But at European level, what we are trying to do is to grant the right to organize and to bargain collectively to the self-employed, okay? And we believe that the two strategies are totally compatible. So this is not creating a third category as it exists in many European countries. This is granting fundamental rights, and mainly the right to organize and to bargain collectively to the self-employed. And to this purpose, we have been working, and again, with two eminent Italian professors, one working for the Catholic University of Leuven and the other one in the UK, in the London University. And they propose a new concept of worker, which is the personal working relationship. This has not been adopted by the European Trade Union Confederation yet. We are in a self-reflection stage. So we have this research that we welcome. We have been testing this with different legal experts from our unions, and to our positive surprise, this has been welcomed by colleagues coming from very different industrial relation backgrounds, including the Nordics, who always challenge any attempt to have a European approach to the definition of worker. So let's see, because this definition would basically provide a very broad definition of worker, in which self-employed workers, as we can understand a worker of a platform, could be granted the right to organize and to negotiate collective agreement, or to extend existing collective agreements to these workers. And then you were talking about this the positive competition between the sectors when it comes to apply an already existing collective agreement. At this regard, I wanted to share the concerns of our colleagues from EPSU, the European Federation of Public Services, because they see that in their sectors, public sectors, platforms are also arriving. They are trying to also undertake a foresight approach to see what the impact is going to be in 3 years' time, to avoid a situation like the one which is existing in the logistics sector, for example. And what they see so far is that this clash between different sectors is having a very negative impact in workers. For example, we see that in the care sector, in many countries, there are nurses who are providing care work, and they through a platform, and they are covered by the collective agreement or the law related to domestic work. So we see that there is a new threat coming from this blurring the borders between the sectors, and how the platform economy is going to boost this blurring situation. Thank you.
Nacho, Victor, vous avez demandé.
Victor, you asked for the floor.
It's Victor Bernhardt. I work at Unionen, the largest union in Sweden. Thank you, organizers, for convening this meeting, and thank you so far for all the interesting presentations. To share a bit about the Swedish context as replied to the original question, as some of you may know, Sweden has a very high level of collective bargaining coverage. About 90% of workers are covered, which is actually a growing figure. Unionization is about 74% of the workforce. So we have, of course, a very good basis to jump from when it comes to looking at how to organize the platform economy, the gig economy. And Unionen reached its conclusion quite early on in our process that, well, we don't really need to invent anything new here. We can look at sort of this gig company are working in what sector. Okay, this is a temp agency, or this is the transport industry, or this is whichever sector it might be. What type of work is produced, and then we will try to organize that platform firm with the already existing collective bargaining agreements that we have. Because as we have, we sign some 100 collective bargaining agreements. All of them are, of course, very different. They have very specific attributes depending on sector, meaning that we are used to negotiate the specific concerns of our sectoral counterparts. And since we are lucky to be such a large union, we can compare between different agreements and see, sort of find common strategies, even though in the long run, in the end, the agreement might be different in the details. So we have a few signed collective bargaining agreements with platform firms on the private sector, white-collar workers. Those are the ones you organize. And during lunch, if anyone wants, I can give more specific examples or war stories on how we got there. But to get back to the original question, I would very much agree that, at least for our perspective, it's of course key then to have platform firms realize that they are employers. If we would take them through the Swedish legal system, most of them would I would say, by a large amount end up as employers. But then again, of course, being the union that we are, using the tactics we use, we try to not take them to court because we want to solve things before that. For a company like Uber, which we wouldn't organize because that's the transport union, they have legal issues with the Swedish authorities that have stalled because the authorities can't get to the servers because they are in the Netherlands. But otherwise, I would say that we have had many positive experiences with the white-collar side platforms, because these are usually entrepreneurs that have this great idea of wanting to do something great. They just don't really know how the labor market functions. So we try to teach them that. So it's a bit of, civics A. Look, this is a union, this is an employers organization, this is what you can do together. Oh, that's a great idea. Yes. it works for everyone. 90% of the work is organized and so on and so forth. And for the politics side, we then come to the challenge there will be rather to look at how do we make sure that the welfare system is adapted to anyone who works in the labor market, not just only people who have permanent positions in long-term employment. So that's something that we've always been working on, because of course these are temporary employed people, but temporary employed people have been in the labor market forever. So this is not a new challenge, in and of itself. And this is, I guess, all of our national contexts are quite different in some respects. I'm not going to sort of try, you do this because that's going to work for you, because of course you need to look at yourselves. But one advice that has been guiding for us, both in our work with both our colleagues and our counterparts, is that we don't necessarily need to invent new things. See what things that we have that we can already adapt has been a very sort of good strategy for us.
Merci beaucoup.
Thanks very much.
Sí, para...
Yes. Let me at least try to answer some of the questions. I entirely agree that the companies, these digital platform companies, want to avoid recognizing the working conditions of their workers, because recognizing that their workers are workers would involve a cost for them, and it would be to the detriment of their profits. In Spain, very big food delivery companies like Globo have said that if the courts recognize that the status of these workers is salaried workers, then Globo would have to go out of business because it wouldn't make any profits. And the same happens with Deliveroo, etc. Because these are platforms that are based on avoiding working costs and avoiding labor regulations in order to maximize their profits. The UGT is very clear on this. Our union strategy, well, I really see no other alternative than to fight for the recognition of these workers as workers. We don't think that there is any alternative to that approach. So we haven't made declarations of rights other than proper labor rights as defined by labor law. Our strategy today is completely focused on the recognition of their status so that they will be afforded the protections and the rights, the same ones that are given to all the other workers. In Spain, contract like the catering contract does not apply to all the activities of the platforms. That convention, that if those workers are recognized as workers, then those contracts would apply to the workers who deliver food to homes, but not, for example, people who deliver packages. That would be another contract. That would be the agreement covering transport or logistics workers if they were recognized as being workers. Now, I have a question for Ignacio. I don't know if he could elaborate a bit on this the relation, the labor relation that he referred to, the individual worker. Is that something that's like halfway between a self-employed or a salaried worker? I'm not sure what he means. At any rate, although I don't really know what the situation is, my initial reaction is that if that new category were to happen in Spain, that would mean that we'd have traditional salaried workers, we'd have self-employed workers, and we'd have economically dependent self-employed workers, and we'd have a personal labor relation. That's another category that I don't quite understand. Perhaps you could answer that.
Yeah, sorry, Ignacio. Yeah, just 1 minute. Yeah, if I correctly understood, the point of Ignacio was just to refer to a study that Valerio De Stefano and Jeremias Prassel are elaborating. In particular, Jeremias Prassel, he is a pupil of Friedland, Mark Friedland, that is a labor law professor, scholar of Oxford University, and he elaborated more than 10 years ago a huge book that is called Personal Relation in Employment Personal Relation. And it's not a third kind, it's just, a theoretical frame to understand the employment relations. But however, it's not very key in this moment to go on that, if I can. Yes, just, yeah.
Yes, thank you. But it is not, it is indeed Valerio De Stefano, and the other researcher is Nicola Contouris. But anyways, indeed it's not aimed at including a third or fourth category in the countries, but to change the approach to the definition of worker and to grant workers more rights. Especially self-employed workers, fundamental rights as the right to organize and to bargain collectively. Anyway, I will send you the report, which is only in English. I can send it to you so that it's shared with all the participants to the seminar.
Je propose qu'on...
Let me suggest we stop this session so that we can make some headway in our agenda. Let's go on to the next part of our meeting. Initiatives concerning regulations. 2 examples, Poland and France. Regarding social responsibility of platforms in France, and one on a legislative initiative in Poland to apply legislation for drivers in the passenger transport sector. Now, let me first of all thank Mr. Lutzak from the General Inspectorate to be with us, because he can correct us if we make any mistakes or inaccuracies when it comes to social responsibility of platforms. In the French context, that inspectorate issued a report on the platforms and social protection, which was a very influential report. For those of you who aren't French, let me tell you that there is an intense debate going on today on the future of a certain number of initiatives taken by the government starting in 2016 regarding social responsibility of platforms. Right now, there's a draft bill which is being debated in Parliament on that. So you have to keep in mind that this subject of social responsibility is being very fiercely debated in France. Let me begin with 3 examples. About 3 days ago, Alessandro Selli, Director General for Europe of Deliveroo, wrote a column in, I think it was Le Monde, but anyway, a French daily, I'm not sure which one, said, with charters, France is succeeding in what no other country has accomplished, to put the platforms before their social responsibilities and to preserve the French social model by whilst integrating new forms of work. And that's the Director General for Europe of General Manager for Deliveroo. And then there's a certain number of the National Council for the Digital Economy, represented here to this seminar, wrote another column regarding these charters. They say that the charter might involve unwelcome change in a social model, a third hybrid status, whose conditions would be decided by the courts on a case-by-case basis. So this reflects a very intense debate going on in France regarding these charters. What you should keep in mind is that this is an extremely topical subject today in France, and it's a debate which is shifting, which is changing in several ways. Now, the French approach to social responsibility, if I can sum it up in a few words, is that there is a certain temporality. The new players who are emerging, who are not really covered by any existing rights or existing law, including labor law. Those activities are activities that are not necessarily new with respect to the traditional activities, though. So one pragmatic approach might be to give priority to improving the rights of workers, whatever their status may be. The basic idea being to provide some stability, to visibility for all the emerging players. And that would exclude certain scenarios, particularly the third status, which could be debated, which might be open to question in France, or the adoption of a certain number of measures, general measures regarding social coverage of independent workers. And above all, the adoption in the framework of a law in 2016 of an article that creates a social responsibility for the platforms through Article 60 of the so-called Law on Labor, August 8th, 2016, if my memory serves me well. Now, that article, which amended the labor law by introducing a new chapter therein, clearly sets forth the social responsibility of platforms. So the first thing that we have to keep in mind is that at first, in the very first version of that draft law, that social responsibility left out, or rather protected the platforms from being re-qualified. And that was modified in the current version, but it's something that was already subject to debate. That is to take a certain number of commitments vis-a-vis the workers, okay, but that would protect the platforms from the legal risk. However, in Article 60, that was changed. First of all, it doesn't apply to all platforms. It applies to the platforms sort of covered by our project, those that set the characteristics of their determine the characteristics of their service provision or the article sold, set its price, and therefore have certain responsibility vis-a-vis its workers. These are like service platforms, like Deliveroo, Uber, etc., the ones you're all familiar with. So there's a certain number of obligations established for those platforms, social responsibility, in particular when it comes to occupational accidents. And there must be they must contribute. The companies must contribute to occupational accident insurance as of a certain threshold of income, which was set by a decree. And there are certain obligations with respect to the recognition of professional experience, the validation of professional experience. The platform also must reimburse certain costs incurred by the workers if they want to add to their professional experience. And there's a certain number of other elements in Article 60, that is the right to refuse organized refusal to provide a service, like the right to strike, and the right for this didn't fundamentally modify their rights because their rights existed before Article 60 was adopted. And let me remind you that in the initial version, all of that excluded the refusal of the link of subordination, but in further debates in Parliament, even that was done away with. Now, it's very complicated to make an assessment of the social responsibility, because as opposed to other laws, the lawmakers did not provide for impact studies. A certain number of initiatives when it comes to coverage and insurance contracts were taken, group insurance policies by the platforms with a certain number of insurance companies. I mean, the insurance company is AXA and Uber and Deliveroo are the platforms. Uber extended its contract to all of its drivers in Europe. And those coverage contracts are under debate because of the guarantees that they provide, because of their coverage. And they haven't been evaluated as such. There's a debate because there's the example of a deliverer who had an accident and the handlebar fell onto his torso, and he realized that the insurance contract only covered limbs, not his torso. So this raised a certain number of questions regarding the quality of coverage. When it comes to training activities, we can't really say that the platforms didn't react. There's a certain number of obligations, particularly in the sector of chauffeurs, of private chauffeurs, which depend on another law, which I won't present here. But anyway, in a certain number of professional prerequisites, one of them was the need for these drivers to pass a test, which also meant that the platforms felt they had to set up training activities. That's not the only reason why these platforms set up training activities, but it's something that we have to recognize with Uber, that is that Uber is making a major effort to train its drivers with training centers. and with a sort of commitment to help these people enter active life, get jobs, and there are certain initiatives involving, for example, online